we struggled on the streets, we faced tear gas and water cannons on the streets, and we demanded justice and equality and freedom for women. The Justice Verma recommendations respected our views, and they brought out a report, a path-breaking report, after having read 80,000 recommendations from all over the country and listened to activists working in the field against sexual violence. They brought out a path-breaking report that firmly changed the way in which our laws and our entire system looks at violence against women. They said that violence must be seen from the perspective of women's autonomy. Any kind of sexual contact that violates a woman's autonomy, that is done when a woman has by word or gesture not said yes, such acts must be seen very clearly as sexual violence. This is what the Justice Verma committee observed, and they recommended that an entire set of changes in the laws and in various other mechanisms must be done to ensure three kinds of things. One is that women's autonomy be respected and protected. Secondly, that the police be made accountable for ensuring that they do justice with any complaint made by a woman. And thirdly, that those powerful people who are accused of rape, the inbuilt provisions which are there in our laws to protect such powerful people must be undone, must be taken out of the way. The ordinance that the government has brought in, claiming that it it is a step towards implementing the Justice Verma recommendations, actually does just the opposite. On all these three crucial counts, the ordinance fails to satisfy the basic benchmark of what it is we were really struggling for. And in fact, it leads us to think that the ordinance, far from being an attempt to implement the Justice Verma recommendations, has been brought in by the government's need to somehow undo and take the sting out of, take the edge out of the Justice Verma recommendations. How is that? Let us take a closer look. The most shocking thing about this ordinance is that it makes the perpetrator in the case of rape or sexual assault gender neutral, which means that presumably even a man can accuse a woman of rape and sexual violence. Just think about what kind of a rude shock and an absolute joke that is with the women of this country. Because today, this ordinance is in place, and if a woman goes to file a complaint of rape or sexual violence against a man, he can turn around and file a counter complaint of rape and sexual violence against her. This is what this ordinance has made possible. How can this ordinance even pretend to be something that has been brought in to help women feel more confident in this country? The other very terrible way in which this ordinance completely fails to respect the whole question of women's freedom and autonomy is the way in which it has automatically criminalized all kinds of consensual sexual activity between young people of the ages of 16 to 18. We all know that young people of that age naturally engage in some amount of sexual experimentation. They may hold hands, they may go a little further. All of this, we all know, is very common. But according to this ordinance, this kind of activity will automatically be criminalized. It will automatically be branded as sexual violence. So a young boy whose only crime would be to have befriended or held hands with a girl of a similar age could presumably be accused of having indulged in sexual violence. What a terrible travesty that would be. The other count on which this ordinance completely fails the test of justice is the ways in which it continues to protect the powerful. Today we have seen the Ruchika Girotra case, we have seen the case of Thanjam Manorama in Manipur, and we have seen so many multiple cases in which the powerful police officers, army officers, judges, magistrates, bureaucrats, if any of these is accused of sexual violence, then we have to take prior permission from the court in order to prosecute them. this is an absolutely unfair thing, because of this the powerful are able to escape with complete impunity. This is why justice has been denied in the cases of Ruchika Girotra or Thanjam Manorama. And Justice Verma recommended that these be changed. He said that the prior sanction, the prior permission provision should be removed. As for false complaints, he said, why should the government be allowed to decide which complaint is false and which is true? Especially when the accused are people whom the government has an interest in protecting. Why can't the courts decide which complaint is false or true, just as they do in every other matter? The other kinds of cases involve the powerful politicians. We have seen multiple instances of MPs and MLAs accused of serious acts of sexual violence and even rape and murder. And in all such cases, we have seen how they manage to get protection, and because of the political clout that they command. Justice Verma had recommended that if any politician is charge sheeted of a serious case of sexual violence, then he should not be allowed to contest the elections, and changes in the laws should be made to this effect. The ordinance completely fails to do this. The ordinance continues to protect a Kanda, it continues to protect a Rajkishore Kesari, it continues to protect a PJ Kurian, who is today the Deputy Speaker of the Rajya Sabha, who is one of the persons who will preside when the Rajya Sabha sits to discuss and decide over what kind of laws should be made for women. What a shame that is. About the question of, and related to this is also the question of custodial sexual violence. When it comes to a case of custodial sexual violence, who is guilty? Naturally, the police officer or the army officer, the junior officers who have actually done the rape are guilty. If the rape occurs in the custody of a children's home, such as that happened in Kanker in Chhattisgarh, then naturally those who actually did the rape are guilty. But are those not guilty? The senior officers, the senior people in authority, are they not guilty if they either ordered the rape to happen, or they knew it was happening or it was about to happen, but they did nothing to prevent it, they turned a blind eye? Justice Verma said that turning a blind eye or giving an order or knowingly allowing such sexual violence to happen in custody should be enough grounds for serious punishment even of the senior officers. But the ordinance completely refuses to do this. Naturally, because it feels that its own may be tomorrow accused of such custodial violence, and so they do not want any changes in the law to change the impunity that such accused currently enjoy. The question of marital rape is one which the government and several other people who are generally campaigning against all laws that are brought in to protect women, protect women's rights, they are trying to raise the bogey of marital rape as something that is going to open the floodgates for false complaints and so on. Is this true? We should first of all recognize that what is it about marital rape that Justice Verma said. The Justice Verma report clearly says that the relationship of the accused with the complainant should not be grounds to deny or question the truth of the complaint, first, and second, it should not be grounds to give a lesser punishment. Today, marital rape is exempted from the rape law. Not only that, if a husband rapes a separated wife, a wife who has taken the trouble to acquire a judicial separation, even then that rape will actually get a lower sentence. There is only a 2-year minimum sentence, whereas for rape it is a 7-year minimum sentence. How is this fair? Basically, you are saying that if you were once the wife of a husband, he is somewhere justified, somewhere we are lenient with him if he rapes you, because the fact that you were once his wife somewhere gives him a license to imagine that you are his sexual property. It's very clear that the marital rape exemption, as Justice Verma report observes, is linked with the idea of women as the sexual property of men. And this is what is actually the grounds for rape in general, for sexual violence in general. And so it is crucial that this be changed and this be challenged. And why should this be feared in any way? We all know that we have all seen how even in cases of terrible wife battering and domestic violence, how difficult it is for activists like us to persuade women to actually file a complaint against the husbands on whom they are dependent, under whose hands they are, in many social and economic ways to whom they are bound. So the very fact of bringing this marital rape into the ambit of the rape law will not in any way lead to false complaints. Rather, it will democratize, it will help to democratize the marriage relationship. It will help to establish that relationship on the footing of equality, on the footing of freedom, rather than on the footing of wives being seen as the sexual property of men. And doing this is very important to challenging the notion of women as sexual property of men in general as well. We also should ask about the question of accountability of the police. It is true that the ordinance to some extent expands the definitions of sexual violence, and it says that stalking or voyeurism, that is making an MMS, or acid throwing, such sexual harassment, that these are crimes too. That's true. And it does have expanded sentences for all of this. But the question is this enough? Justice Verma report very clearly said that it is not enough. Why is it not enough? He said it is not enough because the police can still just refuse to file an FIR, and there is nothing to deter the police from doing so. In order to deter the police from being able to deny justice in such matters, Justice Verma had recommended a 5-year punishment for police personnel who fail to register an FIR or who otherwise conduct a biased inquiry, a biased investigation. The ordinance has reduced this 5 years to a mere 1 year. So they are clearly giving an indication to the police that a 1-year sentence is plenty, that we are basically lenient towards any acts of wrongdoing and law breaking on the part of the police. There is another matter in which the ordinance differs from the Justice Verma report, that is regarding the case of the death penalty. The Justice Verma report very clearly said that the death penalty is not in order. The reason for that is because, see what this ordinance has done. They have brought in the death penalty for cases of rape which result in murder or in grievous hurt to the extent of causing a person to be in a woman to be in a vegetative state, permanent vegetative state. Now, what does this change exactly? In the first place, in the case of rape and murder, your existing laws are already more than enough to allow for the death penalty if so called for. By bringing it in for causing a permanent vegetative state, what does that change actually mean for women who are at the receiving end of the violence? Take the Delhi rape case. In the Delhi rape case, the rapists did terrible injury to the woman, but they did not take care to ensure her death. They flung her on the street, she fought for her life, she survived, and her statement today makes that case all the stronger against the accused. In future, with this ordinance in place, similar rapists will make sure to ensure the death of the victim so that she is not able to testify against them. For after all, what is it they risk? For murder also they risk being hanged, and for a rape also, if the risk is the same, what is to stop them from ensuring that the woman, their victim, is not able to testify against them? So this is actually something which is quite dangerous for women, and this is why the Justice Verma report had stopped short of recommending the death penalty. And in no way does this ordinance do any kind of justice for women. It does not do what we asked when we were struggling on the streets. We asked that women's autonomy and freedom be respected. The ordinance disrespects this. The ordinance mocks at this. We asked that the impunities which are built into the law for the powerful be removed. The ordinance completely mocks this. It completely fails to do this. We asked for accountability for the police. The ordinance fails to do this. We asked that demeaning, misogynist tests like the two-finger test for rape, which rape survivors have to undergo, which is like a medical re-rape, is something which should be prohibited. The ordinance fails to do this. All of these things that we fought for, the ordinance has failed to do. So we have to tell the government very clearly that the ordinance is something that is an eyewash. We refuse to accept this eyewash. On February 21st, we will be there in large numbers at Parliament Street to say that we are here to watch what justice you do with the Justice Verma recommendations. We want to see what Justice Parliament will do, not only in terms of bringing in pro-women laws based on the Justice Verma recommendations, but also to see if the budget in the budget session of Parliament will back with actual funds the recommendations of the Justice Verma Committee. Will they ensure more funds for more courts and more judges? Will they ensure more funds for safe houses for women? Will they ensure more funds for forensic facilities, for rape crisis centers? Or will they continue to spend lakhs of crores on tax giveaways for the very rich and for big corporations? This is something we are going to be there in large numbers outside Parliament starting the February 21st, which is the day that the budget session of the Parliament starts. We hope that all of you who are seeing this video will join us in telling the government that we are here to be watching them in a people's watch over Parliament starting the February 21st.